Assault. What is a tort? The word tort has been derived from the word tortum, is a Latin term which means twist. The law of tort consists of wrongful acts whereby the wrongdoers violate some legal rights vested in another person. The law imposes a duty to respect the legal rights vested in the members of society, and the person making breach of that duty is said to have done the wrongful act. Violations may be due to intentional acts, breach of duty, or violation of law. The party who has committed a tort is known as tortfeasor. When a tortfeasor incur tort liability, which means that they have to compensate the victim for the harm which is caused by them. In other words, the tortfeasor will have to pay damages if he is found liable or found responsible for a person's injuries. The law of tort in India has evolved from the law of torts in the UK, which is most popularly known as judge-made law, and the law of tort does not come from a statute and is uncodified. Despite this, it has existed for many years, although the number of cases of tort have declined. The number of cases of tort or tort litigation is less as compared to the cases of tort filed in Britain and the United States. The Indian law of tort got its shape after the principle of law of tort developed in the UK. Most of the landmark judgments of tort in India is based on the judgments of House of Lords/courts in England. In India, the tort cases are tried in civil courts and the relief awarded includes damages by way of monetary compensation or an order of injunction or restitution. The law of tort serves two basic, common objectives. 1. Compensation to the victim for any harm resulting from a breach of defense. 2. Discouraging the rescuer from repeating the violation in the future. Examples of torts. Some common examples of torts include 1. Negligence-related claims. 2. Civil assault/civil battery. 3. Wrongful death claims. 4. Trespassing. 5. Products liability and dangerous product. 6. Intentional infliction of emotional distress. Assault. In common law, assault is a tort, an act of the defendant which causes to the plaintiff reasonable apprehension of the infliction of a battery on him by the defendant. When the defendant creates his act by an apprehension in the mind of the plaintiff that he is going to commit battery against the plaintiff, the wrong of assault is completed. The wrong consists of an attempt to do harm rather than the harm being caused thereby. In assault, charges must include conduct that is offensive, which is offensive or causes another person to the fear of their safety. This clearly means that one can be guilty of assault even if she did not physically harm the victim. In the case of R. v. S. George, the pointing of loaded gun to another is an assault. If the pistol is not loaded, then even it may be an assault, if pointed at such a distance that it may cause injury. If a person advances the manner of threatening to use force, then there is assault. This was decided in the case of Stevens v. Myers. Elements of assault. If one or more elements have not been satisfied, then it can be a defense to an assault charge. Elements of the crime of assault are an act or conduct intended to prove a criminal attack. The defendant's behavior must be motivated to create a situation of fear or danger in the victim's mind. Accident acts do not include allegations of assault. A reasonable apprehension. Further, the victim must reasonably believe that the defendant's conduct will harm or humiliate him. The victim must understand the defendant's potentially harmful or offensive acts. Of imminent harm. The victim's fear must be a direct response to a threat that is imminent. Future threats, such as "I will beat you tomorrow," will not result in assault charges. In addition, there must be some kind of perceived physical threat to the victim in the loss. For this reason, words by themselves generally do not constitute an attack. It is believed that the defendant's actions would cause physical danger or abusive behavior to the victim. Thus, the pretense of kicking or punching the victim may be an attack, as will attempt to spit on the victim, aggressive behavior. All of the above elements must be present and the evidence must be supported with evidence if found guilty for the attack. It can be difficult to prove whether the defendant actually intended the attack. Similarly, judges often spend a lot of time determining whether a defendant's actions are considered harmful or abusive. In determining this, they will consider what an average person may perceive as harmful or aggressive legal defenses on charges of assault. As with other types of criminal charges, there may be some defenses to assault charges. This will depend on each individual case, as well as other factors such as state law. Faults commonly charged with assault charges include 1. Self-defense. This could be a defense if the defendant was acting out of self-defense. They should only use the amount or display of force that is appropriate in the situation and in proportion to the force being used against them. 2. Intoxication. In some cases, intoxication can be a legal defense, especially in cases where intoxication affects a person's ability to act intentionally. 3. Coercion. This may be a defense if the defendant was forced to attack under threat of harm, for example, if they are being held at gunpoint and for assault at the behest of someone. 4. Lack of proof/proof. As stated above, if the elements of proof are not found or supported with the correct evidence, it can serve as a legal defense. Many other types of avoidance may exist depending on the circumstances. Remedies. 1. Action for damages. Whenever the plaintiff has been wrongfully detained, he can always bring an action to claim damages. Compensation may be claimed not only for injury to the liberty but also for disgrace and humiliation which may be caused thereby. According to McGregor on damages, the details of how the damages worked in false imprisonment are few. Generally, it is not a pecuniary loss or of dignity and is left to the jury and their discretion. The principal heads for damage would appear to be the injury to liberty, i.e., the loss of time considered primarily from a non-pecuniary viewpoint, and the injury to feelings, i.e., the dignity, mental suffering, disgrace and humiliation with any attendant loss of social status. 2. Self-help. This is the remedy which is available to a person who, while he is still under detention, instead of waiting for legal action and procuring his release thereby. 3. Habeas corpus. It is speedier remedy for procuring the release of a person who is wrongfully detained. Such a writ may be issued either by the Supreme Court under Article 32 or by a High Court under Article 226 of Indian Constitution. By this writ, person detaining is required to produce the detained person before the court and justify the detention. If the court finds the detention is without any just or reasonable ground, it will order that the person detained should be immediately released. Conclusion. Assault is an attempted offense. The law is intended to prevent possible battery by punishing conduct that comes in a dangerous way to obtain battery. As with most attempted crimes, a clear line cannot be drawn between a criminal attack and conduct that is merely an attack preparation. There should be an intention to cause harm, but it is not enough if it creates the possibility of damage or the danger of battery in a distorted future. Instead, the intent must be taken out of imminent danger, some overt act that endangers the battery. Thus, words or intentions do not constitute mere attack.